Any mention?
My lord, this item number 6, my lord. The state was directed to, my lord, obtain some instruction, my lord, clarifying on the percentage of, my lord, reservation for the special category. We have received the instruction, my lord. We'll bring it on record by way of affidavit.
Item 6.
My lord, I'll inform the other side, my lord.
But then, is there any order
My lord, yes.
directing you to file an affidavit?
My lord.
Affidavit, it is there.
Not affidavit, my lord. To bring instructions, my lord. I pray I may be allowed to bring it on record by way of affidavit.
It's okay. Then allow the matter to come.
My lord.
May I please, your lordship? Lordship, I beg to mention item 8. Mr. Philemon Nongbri is indisposed, so if this matter may kindly be taken up after 2 weeks, lordship.
Who is indisposed?
Yes, lordship. Kindly. Mr. Philemon Nongbri.
Mr. Philemon Nanguri is indisposed.
Yes, lordship.
After 2 weeks.
Kindly, your lordship.
We have no objection, your lordship.
8. At the request of the petitioner. Yes.
Lordship, I pray a similar prayer for item 9 as well.
Who is other side in the item 9? No objection. Okay, 9 is the same order.
Much obliged.
Mr. Lordship, I should beg to mention item 7, Lordship.
Yes.
We have a Mr. Chandais. Some personal difficulty today, Lordship.
Now all the service matters have come back here again.
Lordship.
You could not finish it there.
No, Lordship.
When do
It's
you
a
want?
part heard matter, I think, Lordship.
Is it part heard?
It was a part heard, that's why it's come back, Lordship. Maybe for that reason.
This matter was part heard by this court. No.
Some occasion, Lordship.
Many matters have come back. This is not only the one.
Lordship,
matter.
I've seen that. After 2 weeks, Lordship.
No objection, Lordship.
This is also after 2 weeks of the request. Yes.
Highly obliged.
Much obliged. Item number 1.
Yes.
Well, this matter, land acquisition matter, in the earlier occasion, I sought for deferment of the hearing because of the pendency in the before the land division bench. Other side objected that this matter do not need to wait the outcome of the division bench matter. So there was 2, 3, 4 occasions they did not raise an objection with regard to the connectivity or relation with the division bench matter. And in view of that objection, Lordship fixed the matter today here. Now, before I proceed on the merits, I would show to my Lord few annexures, including my prayer, that will convince my Lord to show that this presented petition has a, or in other words, the issue that is involved in the division bench matter would have a direct bearing in some of the important issues in this instant writ petition. Now, the issue is whether it is the expansion of the road. Now, according to the record of the respondent, the social impact assessment report also prepared. They conducted the survey, and in their report, they say that existing road.
This is acquisition order 2013. 2013.
Yes.
2013.
2013. The report says that the existing size road of the existing road, the size of the existing road is 4.75 meter, including carriageway and soldier. So that was the report of SIA, part of the government record. Now, on that basis, the collector started the process of conducting inquiry and surveying. And now the issue crop up that the NHITR says that initially they plan to acquire 20 to 35 meter for expansion of the road. And that was placed before the Japan International Company, who is a sponsoring body. But the sponsoring body said that the cost would be huge, so you reduce it. So therefore, they reduced to 10 to 20 meters road for expansion. And when the process going on, several meetings was held. And the issue rise up with regard to ROW, right of way. Now, SIA report say that 4.75 is the existing road. Now, therefore, if they go by the report given by SIA,
Right of way, is it not defined somewhere or somewhere? It is specified in some laws.
Madam?
The right of way, so far as the how much land is to be left as right of way by the
Yes.
side of the. Is it the issue here? No.
That is the issue, madam. Now,
Is it not that is provided somewhere in some law?
no, madam, when we sit in Indian Road Congress, the elaborate documents are provided. And there we can find what is ROW. ROW consisting of the carriageway, soldiers, drainage, everything. Now, therefore, if the government acquire 10 meter today, and they do the blacktopping of 5 meter, remaining left are part of the ROW, including the blacktopping and the untouched area. These are called
ROW has to be within the acquired land.
within the acquired one.
That is what.
That is the issue. Now, therefore, the record,
No, but then is it disputed? It cannot be disputed. I am the only there is a dispute that ROW
there is a dispute of ROW.
cannot be outside the acquired land.
That is why. That is why. Now, therefore, when the collector proceeded for meeting one after another, then the NHIDCL desired to have 10 to 20 meters. Now, the existing road is only, as per the report, 4.75. And therefore, they call the representative of the GHTC, and GHTC apprised that we used to issue a PATA. And when we used to issue a PATA, we mentioned clause 4 in the PATA. And in that clause 4 PATA, we used to mention that 35 feet, that is a 10.67 meter from the center line, is mentioned that this should not be utilized. That means, well, this is the middle of the road. From here, 10 meters, right side also 10 meters. So it comes around 20 or 21 meter. So that should not be part of the acquisition. Now, therefore,
That should not be a part of acquisition.
part of the present proposed acquisition. So therefore, collector was also confused. And when they sit in the meeting, NHITCL representative said, no, that 20 by 20, 10 by 10, both sides in 20 something. Perhaps it was acquired by PWD long ago. It was a version of the NHITCL implementing agency who has zero knowledge about this. They said the PWD would know, since it is a PWD before declaration of this road as a national highway, so they would know. And therefore, PWD is supposed to clarify. What
is your case here before this? You see, like this way, it will be difficult to understand the facts of the case.
ROW, no?
So your issue, which has been raised here in this petition, what is the prayer?
My prayer is, my Lord, for setting aside the Section 11 and Section 19 declaration, along with the letter issued by District Council.
Can it be done?
Yes, my Lord. Because I challenge the acquisition itself. My Lord, can you see my prayer, page number 84J?
84.
84.
Yes.
84, my Lord. My prayer to set aside the impugned minute dated 3rd August 2018, adopted by the collector. Here, he accepted the ROW given by District Council. Therefore, I say that District Council ROW is challenging the division bench. Impugned preliminary notification, we challenge. Impugned report of the alleged Section 5 hearing Section 15 hearing. So there was also hearing according to us. And for relief is impugned letters and such. 14 February 2020 issued by District Council saying that the 30 feet from the center line should not be a part of land acquisition. That was the letter issued by District Council, and we challenge. And they have issued that letter on the basis of the Karo Hill District Council Land and Revenue Regulation 1954, which is a salient division bench. Impugned declaration. And the relief directly respondent, specially respondent collector to conduct fresh survey and take measurement of the land, including 8 and such more or less meters within stretches situated from the edge ending of the existing, should be existing, 4.5 meters of National Highway 51, Coral Hills and such. And other prayers are there. Now I will show, therefore I am making an attempt to show that to avoid confusion, therefore all along I was praying when division bench made a cease-off on the petition filed by the Karo Hill Nokma Council, and subsequently one of the writ petitioner, Matthew, one of the writ petitioner, he has also filed before division bench, it is pending. Now therefore, suppose I can proceed on the hearing of the entire case, because I challenge the acquisition itself. If Lordship do not satisfy acquisition, my writ will be dismissed, acquisition will continue. And if I succeed, then Lordship may direct the collector to hear.
Challenge to the acquisition proceeding,
Yes.
normally.
Yes. It is clear, my lord. When hearing, with some earlier section 4 hearing, section 5A hearing under the All Act 1894, and now section 15, the law is very clear. If the collector do not give offer an opportunity to the interested person, affected person, on that ground alone, it can be struck. Acquisition can be struck.
So you say that you are not given an
Oh,
opportunity.
yes, that is my major grievance. Other factor, my ROW, other meters, these are the nitty-gritties
So
of
now
the...
if any opportunity is created to you, then say supposing,
Yes.
can it be done that this thing, like you may be given a opportunity to be heard?
My lord, here I have seen it cannot be done because they have issued section 11 and section 19. Had they not issued section 19 declaration, opportunity may be given to me. Now, because the section 11 is very clear.
Section 19 is section 6 of the previous act.
Yes, yes,
Declaration.
yes,
So after publication of declaration, they cannot.
exactly, exactly. And how section 19 declaration is given by the government, Lordship is very much aware. They issue section preliminary notification section 11, and section 12 they enter into a detailed survey, and they will give a notice to the affected person mentioned in the preliminary notification, and within 60 days they can file an objection and opportunity should be given. Now the collector, my lord, need to hear me, need to receive my objection within 60 days. Number two, he has to give me opportunity of hearing. Now, had he give me the opportunity, I would place this. All this, the ROW, what is ROW, what is not ROW, what was not aware, what was aware, what is existing law, I would have placed. Now, he did not give me.
2013.
Lordship Guide is section 15.
Yes.
It says, hearing of objections, any person interested in any land in which has been notified under subsection 1 of section 11 as being required for or likely to be required for public purpose may within 60 days from the date of the publication of the notification object to the area and suitability of land proposed to be acquired, justification offer for public purpose, findings of the social impact assessment report. Every objection under subsection 1 shall be made to the collector in writing, and the collector
Yet
shall
the
have...
preliminary notification was issued on which date?
It was issued on, my lord, July
July of?
2019.
And when did you file your objection?
Objection within less than 60 days I filed. Some of them, 60 of them filed.
Okay.
Yes. Now, in writing, and the collector shall give the objector an opportunity of hearing in person or any person authorized by him in this behalf or by an advocate, and shall, after hearing all such objections and after making such further inquiry, if any, as he thinks necessary, either make a report in respect of the land which has been notified under subsection 1 of section 11, or make different reports in respect of different parcels of such land to the appropriate government, containing his recommendation on the objections, together with a record of the proceedings held by him, along with a separate report giving therein the approximate cost of land acquisition, particular as to the number of affected families likely to be resettled, for the decision of that government. The decision of the appropriate government on the objection made under subsection shall be final. Now, this is very crucial. After he received my objection, he has to give me an opportunity of hearing. My names are the in serial number.
There was no heard. You were not heard.
No, my name was in section 11.
After a hearing, that collector has to file a report to the government, isn't
Yes.
it? Once government accepts it, then they,
Section 19 comes.
yes.
Yes.
Whatever the government decision, that becomes, that it is finality so far as the objection.
Yes. Yes. Because
So now that has not been done here. Is it the admitted position?
that is true. They have filed detailed affidavit.
Then why you are going into all other things?
And therefore, the ROW was part of one of the government issue here. Therefore, connected with the file. Therefore, if lordship
No,
differ.
but then say
Otherwise,
supposing whatever the thing outcome the hearing, if it is solely for the reasons of violation of section 15, then we can pass an order now only. No, but then we cannot send it back, isn't it? For hearing you on objection.
Therefore, now lordship has pointed out whether lordship can send me back to collector for hearing. Now, it cannot be done because government has taken a decision and they have notified in section 19. Now, therefore, government section 19 declaration is solely depend on the quality of the report given by the collector. Because government is not the one who conduct the survey. Government is not the one who made the inquiry. It is the collector only under the LA. Now, whatever the collector give a report.
What is the consequence of non-compliance of section 15?
Section 15, my lord, there is a judgment. Let acquisition strike down and given liberty to the government. If they want to acquire, you start afresh.
Fresh proceed.
So that's fresh proceeding. I cannot prevent them forever.
Same thing can be done here.
That is my prayer.
What is the decision of that thing?
But-
Is this the thing? See, like if that be the thing, if it is an admitted position, then do you need to go to other aspect of the matter?
But in that case, my lord, therefore, if lordship desire, that no need to go to other aspect.
What you say, whether these are all Mr. Shen, is it correct that this thing, no opportunity was given for hearing and all?
Before that, I have another issue because for them to raise the question of section 15, they'll have to meet the issue whether their person's interested.
Yes.
I have a question with that.
Yeah, that
But then
makes sense.
once they
Unless
file,
their person's interested,
just a minute,
lodge.
the fact remains that if they have filed an objection,
Gotcha.
then definitely you see, if you reject that application saying that they are not interested person, that is okay. Have you done that?
Not.
They didn't.
I'll just come to them. I'll just take your notice through some of the averments that they have made, which are completely contradictory to what is before the collector.
But then you see, like, it would not affect the main issue raised here.
Gotcha.
Say, supposing in the proceeding, after you publish notice under section 11, and then the objection comes to you, you have to afford in hearing, because even also not for the determination of the merits of the objection, even for the purpose of determining whether they come under the category of interested person or not. Having not done that, where is the question of raising it here?
Just hear me on some on one preliminary point. Like lordships have also passed some observations in a particular case very recently, and there's a Supreme Court decision on it. I'll just take a few minutes now. Kindly have the writ
Do not make
petition.
it very complicated.
No, not very. Just kindly have the writ petition, my lord.
Yes, we have that.
Page 23. Because even before we go into that merit of whether they are interested parties, lordships will see whether this writ petition in its present form is maintainable. my lord. And you have page
So you are
23,
on the question of maintainability.
maintainability. Because there are a total of 89 petitioners which are before lordships.
Yes.
At page 23, para 3.
Yes.
This reads that the brief factual matrix of the incident case is that all writ petitioners are the landowners and private individuals holding periodic land pattas issued by the respondent GHTC. So therefore, they say each and every single person is an individual who's before this court, and every single person is a landowner holding a periodic patta issued by the GHTC. Now, we raised an objection with regard to that, and there again they filed a rejoinder.
You raised an objection on what ground?
On the ground that there is a non-compliance of Order 1 Rule 8, because this appears to be a case in representative capacity.
Okay, yes.
There is no authority. And who are these people masquerading as landowners? And we specifically refer to one of the petitioners here. You'll also will see the cost title at page 19. Sorry, at page 10.
Yes.
At page 10, petitioner number 23.
Yes.
Can you see this one? Chitoktak Community Hall. And their specific averment is that these are all individual writ petitioners holding a periodic patta, and they're landowners. So we raise these objections
Now,
before the court.
supposing if this writ petition goes
Lordship,
as against the petitioner number 23,
Lordship.
others remain.
No, still, I'm just coming to that one. Because there are 89 petitioners, there is no authority.
How can that be a community hall where a party here?
Exactly. And they know, anyway, in the rejoinder, they've sought to cover that by making a statement that this is a registered society. And if Lordships will have their rejoinder.
Even if it is a registered society, it has to be represented by somebody, isn't it?
Correct.
Then?
So these are all these issues.
But that is
So
okay,
there is a
but
non-compliance
see,
of
like,
Order 1 Rule 8. And I'll just refer to a decision of the Honorable Supreme Court on this issue. Kindly have the rejoinder, my lord. The rejoinder that has been filed by the petitioners.
Very difficult file. You have made this file such a thing, you see. Difficult. We cannot see two files at a time.
I don't know. It was already a very voluminous writ petition.
Size of the affidavits are also not very small.
Yes, Lordship.
It's very difficult, like which way to see, what to see. In pathetic condition. This is of which year?
This is of 2020.
Yes.
If your Lordships have the rejoinder, kindly turn to page
Rejoinder
20.
of
The rejoinder filed by the writ petitioners.
who are respondent number 12 and 13? Union of India.
Union of India, my lord. No, I am for 1, 2, 13. For the state, 12 and 13 would be the commissioner.
Who is they have filed a separate affidavit.
We have filed a separate affidavit on behalf of 12 and 13.
Who is respondent number 17?
17, my lord.
17 is
17 is the institution which conducted the social impact. Our role is only to conduct the social impact, not a very necessary.
and 16. Then
16
affidavit is
16 is NHIDC.
very difficult to send. These pages are not in proper order. See, it's not in proper shape. See, things will very difficult.
Perhaps we'll have to convert it into A4, my lord.
Is this rejoinder filed on 7th?
The rejoinder
7th
filed on
April
7th of April 2022.
Yes. Yes.
So kindly have page 3 of the rejoinder, para 6.
Yes.
This reads that with regard to the averment made in para 6 of the affidavit, the answering deponent deny the correctness of the same and further submit that the writ petitioners are the bona fide absolute and rightful owners of the land situated adjacent to the existing road as per the prevailing land tenure or customary laws of Garo society, and the above land are merely regulated by the respondent GHDC.
You are reading?
Only
You are reading?
para 6 at page 3.
Yes.
That with regard to the averment made in para 6.
Para 3B.
So the one that I have, this is what I have received. The rejoinder, well, there's a rejoinder filed to the affidavit by 12 and 13.
Here. This is 16. Twelve and 13.
12 and 13.
Yes.
Page 3, para 6. That with regard to the averment made in para 6 of the affidavit, the answering deponent deny the correctness of the same and further submits that the writ petitioners are the bona fide absolute and rightful owners of the land situated adjacent to the existing road as per the prevailing land tenure or customary laws of Garo society, and the above land are merely regulated by the respondent GHDC only for the limited purpose of administration, assessment and collection of the land revenue under the Garo Hills Autonomous District Land and Revenue Regulation 1954 by issuing pattas in favor of some around 52 number of writ petitioners, and remaining writ petitioners do not have the patta issued by the district council. So therefore this was in stark contrast to the original statement made in the writ petition.
But in which way it's relevant here?
Well, there is no nexus of these petitioners to this land. Kindly see the community hall. That is not even a juristic entity.
The question is that who filed objection in response to Section 11 notification?
Lordship. So the question is, how many of these people are?
Are you saying that this writ petitioner have not filed any objection?
No, I'm saying this writ petitioners cannot maintain it in this particular manner. I'm just referring to a judgment of the Honorable Supreme Court on this issue. Because in the absence of any specific authority, they can't maintain a writ petition like this. 89 people cannot come before the court. And further, your Lordships also recall, out of these 89, several petitioners are before the court who've deleted the names.
You see, 89 people coming together here.
Lordship.
That is basically you have not responded to their by raising their grievance against you for your non-response to their objection.
No, I'm not.
This doesn't have with the claim of the ownership. It has no reference with the claim of ownership.
No, I completely understand those are two
At this stage,
different
it is
issues.
not relatable. This court is not at all interested to go into the fact that whether these all the petitioners they hold a piece of land or not.
Lordship.
The question here, this court, what things is proper is for you to answer is that
Lordship.
whether those petitioners there was any objection filed on behalf of them,
Lordship.
and if at all filed behalf of them, whether you have provided them an opportunity or not. That is all.
Lordship. That's the question on merit, my lords. I was just addressing the issue that 89 petitioners cannot come by with a writ petition in this manner. I'm just referring to one single judgment. So what has happened here? There is no dispute about the fact that of these 89, 88 people have not authorized the petitioner number 1. The deponent has not been authorized to file this writ petition. So their order 1 rule 8 comes into play. Kindly have this decision.
Issue of maintainability, you are raising it now, or it was raised earlier.
In my writ petition itself, I've raised it.
Why you are 4 years have gone?
No, it's because on various occasions this matter was never taken up. Then my learned senior friend also referred to the pendency.
There was this thing also, period of cooperate and all those.
Yes, Lordship. And also they referred to the pendency of the matter before the division bench.
So you want to say
Lordship.
that there is no authority, but then if they all are petitioners here,
Lordship.
then
So there are.
it is not that the one person is suing on behalf of others, isn't it?
That's what is supposed to be done. That is what they're projecting here. That one has been apparently authorized by the others. There is no authority letter.
See, without going to these things, this petition has more than one petitioners.
Yes.
It's not that the one person is representing all.
No, they claim that one has been authorized by everybody else. There is no authority letter. There's nothing. There are 89 names. So they're seeking to interfere with the proceedings in respect of those 89 landowners. So what I'm only
saying that one person is representing of this.
Yes, Lordship.
Who is representing?
Well, it's the deponent is Matthew M. Sangma.
Why you are going by deponent? What I do not know. That is, this has become very complicated. Now, for filing a suit
Lordship.
in a representative capacity,
Lordship.
the prior permission has to be taken from the court,
Yes.
isn't it?
Yes. By separate application.
Now, in absence of that, petition will not be maintained.
Not be maintainable against the others, only will be maintainable as against the one person who has launched the original proceeding. So here the question will be who will maintain this writ petition? Because Matthew M. Sangma, who's the deponent, is only one of the petitioners. And the case is maintained in the name of Neelay Sangma and others.
So he is not authorized by others.
He's not authorized by others. So first that hurdle has to be crossed. Now, very recently, Lordships have disposed of another writ petition on that ROW factor.
can
I'm
you-
not going into that ROW issue,
Now, accepting your argument,
Lordship.
can we further proceed in this case
My Lord.
by treating that as a writ petition filed by one individual
One, yes.
and pass the necessary order setting
Only
aside
in
the
respect of that one person.
So pass the order setting aside the accusation because you have not given opportunity.
Then Lordships will hear me on merit after that. Because I'm only asking Lordships to examine
What
this
would be the
aspect
effect?
first.
Say, supposing if this court passes an order,
Lordship.
if you say
Lordship.
that writ petition will be maintainable
Lordship.
only for one person, this will be
My Lord.
as against one person, this will be maintainable,
Lordship.
others will not be maintainable. Now, if you assume that that is correct, now the prayer which has been granted, if
Lord.
prayer which has been made, if at all it is based on what the senior counsel has submitted.
So that interferes only as against that one petitioner, not against the rest.
How can
That person will be given the opportunity.
The accusation be interfered as against one person?
No, because their entire premise
This is a public process. How can we say that this is the subsequent?
Why I'll say this, my lord? Let's say there is a notification under section 11 inviting objections from 89 people. 80 people do not file an objection. Only 10 people file an objection. And those objections are taken on record and some substance is found. So the acquisition is dropped and their objections are entertained only as against those 10 people. Because we are still in the proceedings of the section 19 declaration. So the section 19 declaration will be interfered only as against that one petitioner who claims that he has not been heard. He'll go back to them. They will reascertain whether he is a person interested. He has any title over the property. That's all.
So there is an option of sending it back.
Yes,
without
and
interfering.
Also, my lords will also bear in mind that over the last few months, several petitioners' names have been deleted. They're not party to these proceedings. So, going by the judgment which I've just placed, the case can only be maintained as against one. Now, they'll have to elect who that is. Because as against the name of the person who's maintaining the petition,
You said the person who has signed the thing.
only that person. Now, the interesting thing is they are admitting that he is not a landowner. His wife is the landowner. So, what remains in this case? I know I'm raising a technical issue, but this is the necessary fallout of that.
Yes, Mr. Sangrishna.
I think my learned senior friend has
How
also.
you answer the issue of maintainability?
My lord, I
What
would
the
understand.
Issue, whatever rule it is concerned.
Yes, I would like to go through his judgment. If I'm not wrong, perhaps there might be 10 petitioners that were projected in the court. And maybe perhaps 9 of them or 8 of them did not sign the Vaklanama also. But one person claimed that I'm authorized, and therefore I'm claiming relief for 10 of us. In view of that issue arises.
Vaklanama has been signed by all of them.
In fact, all of them signed.
So it is not that the one person is
Exactly. That is my answer. Second answer, my lord, he is questioning that we are not the landowner. Lordship cannot decide who is the landowner or not landowner. Admittedly, section 11 and section 19 declaration, all my names are there. And therefore, they cannot, my lord.
See, for signing affidavit, is there any authority needed?
Not required.
Order one rule, it will not come into
Exactly.
operation. Once this Vakalatnama is executed by all the person,
Exactly.
authorizing
Exactly.
single lawyer.
Exactly. Even I've seen my High Court rules. I don't come across that requirement.
Then give me some amount of time. As far as I understand, mere signing of Vakalatama does not amount to compliance of Order 1 Rule 8. Because Order 1 Rule 8 requires a petition to be filed. It has to be advertised on all those people.
Petition to be filed
My lord.
when one person seeks to represent many.
Lordship.
That means that one person only executed Vakalat.
Yes.
Exactly.
Here it's not a case.
Exactly.
Here all have executed.
Yes.
No, that's only insofar as the Vakalatama, my lords. He has not been authorized. Vakalatama is a separate issue. That authorizes the pleader to represent somebody. That's all.
Anything on this thing.
So, my lords, I'll just refer to that judgment that I was referring to earlier.
No, but then I do not know. Probably this has never come up before, or we have not dealt with it. But then it is the normal practice. Wherever there are more than one petitioner
My lord.
in a writ petition, It happens only one authorized person, one person executes the affidavit.
Affidavit.
Other all sign affidavit, and that is good enough.
No.
Other all sign the Bagalatama, that is good enough.
So that's the issue. Perhaps it has never been raised. If Lordship see this particular case, this relates to a proceeding under 226. And they've said, because usually what they say is that CPC will not be applicable strictly. But here they've referred to that particular
spirit.
in spirit. But here they've referred to that issue. Kindly have that, my lord. It's a short judgment, 4 paragraphs.
Yes, yes.
This is a writ petition of 1988. So it relates to a writ petition itself.
Yes.
In para 1 thereof, it is averred that it is filed by the individual petitioner in representative capacity. It is not disputed that no application for leave under Order 1 Rule 8 of the Civil Procedure Code was made, no leave was obtained, and no publication in this behalf was effected. Learned counsel for the respondents therefore submits that the petitioner is in a representative capacity is not maintainable. Learned counsel for the petitioner submits that the original petitioner has been substituted by another petitioner pursuant to an order of this court, that the petition has been admitted and that therefore it must be proceeded with as being a petition in a representative capacity. It is for the petitioner to make an application under Order 1 Rule 8. That is what is the requirement.
See, here the matter starts with these things.
Lordship.
It is averred that it is filed by the individual petitioner in a representative capacity.
My lord.
Here it is not the case. Here all are petitioners. All are named as petitioners.
Lordship.
There is a difference. Now, only thing, as you say,
My lord.
that signing of Wakalatnama is not sufficient, then in such a case you have to give us.
My lord. Then kindly have it on Tuesday.
We'll have it after a week, but then and this thing. But then this is, I think, something different. All along practice is that, of course, I do not know.
Perhaps because this issue has never been raised.
In all his
One thing-
ritual
one thing,
fairness,
just keep it in your mind.
Well,
It's not one person represented. All are named as it.
No,
There
I
is not
understand.
only one petitioner who
Correct.
says
Correct.
that I am representing all these 88%.
Lordship.
So that is the difference.
So then in that case, there is no authority
But then
again.
if that, say, supposing, if that your issue of maintainability doesn't stand,
Lordship.
then do we have to wait for the disposal of the PIL?
That is something that is being asserted by the petitioner. Petitioner claims there is a nexus, direct nexus with the case which is pending before the
No, but
division
then
bench.
is it, what do you say? What is your thing?
Well, that would depend because lordships have already decided Kevingston Sangha recently. Again, that issue of ROW came
What
in.
is-
Because their fundamental claim, my lords, let's just understand what their claim is. Their claim is that from that particular,
What this there is a matter on that similar issue decided by
somewhat similar issue on the issue of the 35 feet from the center of the highway.
I have said petitioner never claimed ROW that case.
No, lordships have decided the
never
issue. What the essential
There was no
difference is,
decision.
here my learned
Okay,
senior
okay,
friend
okay.
is
There was
claiming
a case. That was a case.
Mr. Hazarika appeared for
The
They were
petition.
petitioner
admitted
claimed
encroachers.
compensation for that part of the land.
only the loss suffered to their
But then there is an
structures.
admission. There was an admission. See, at the hearing, the council had admitted
Well,
they do not hold. They do not claim that.
Correct.
land.
That's the only difference. In
That- that is-
that is the only
But
difference.
that is the vital.
But lordships have also referred to the patta, the clause in the patta, the stipulations in that patta, which claims and lordships have
And there is a thing.
and lordships have also referred to the Assam Land and Revenue Regulation
Yes.
and come to that conclusion that they rightly do not have any right over the property.
So that is
So
why
it would
this court
follow-
was asking. See, this court vaguely reminds us that was
Right.
asking senior counsel that there is a law somewhere with regard
Right,
to
right.
Yes. Lordships
Yes,
have referred to
Lordship.
that.
We have seen
35 feet from the center of
Yes.
the.
Yes, my lord.
The
In
judgment
that
passed
Assam
by
Land and
Lordship.
Revenue Regulation,
Yes.
Now-
which has been
RO was not claimed by
Now
petitioner.
here, issue is not. We are not going. We are not stretching it that far. Issue is only whether
that objection should have been
consequent to
heard.
Section 11 notification after filing of their objection, whether they will give them. If that and whether that giving opportunity is mandatory.
That is the main issue.
Alright.
And if whether how which way you have dealt. Is it? Are you denying that they have filed any objection? Is it?
No, I'll just take it because there are a lot of names and a lot of names have been dropped now.
Please see
So I'll just
that is-
examine
that
that.
is the vital issue.
I understand.
Kindly verify that.
Lordship.
And one thing, see, prima facie, whatever has been projected by the senior counsel, it appears to be mandatory. If they file any objection, even if you raise a plea that they are not the landowner, they are not the interested person, that you have to say it in
That they'll
while
deal with
disposing
by
them.
themselves.
You cannot take the plea.
Lordship.
Right.
All right.
If my
Or
friend's
is there any
objection,
reason for the people, those whom you admit, they filed the objection? Have you given a reason in your affidavit of opposition? For what ground you have not considered their objection?
It's because there is a lot of details in respect of every individual petitioner.
There is difficulty on your part also.
Lordship. Let me just
My
examine
friend's-
how
my
many people
friend's
have been dropped.
objection.
Mr. Sen, this court knows you to be a very fair counsel.
Lordship. I don't want to.
That is
make
what
any
is
statement.
expected of. Would definitely
Lordship.
not like you to raise some pleas which are apparently not borne by.
Lordship.
if his objection
kindly
is,
keep
my
it
lord,
in mind.
Yes.
then never half of the writ petition, pending writ petition before this court would be not maintainable. 80-90% of writ
Kevingston
petitions.
would have some bearing. The judgment that Lordships have decided. I'm saying that there is a difference in that. In that case, they did not claim any title over the property. Here, the petitioners are claiming title over the property, but the result is the same. Result would be the same.
We may not go that far. Okay, we can mold relief also depending on the thing.
Lordship.
See, we will not say anything about their ownership. But then our concern is that if at all there is an objection, that has to be disposed. That is the mandate of law. Whatever the situation, you cannot say.
Lordship.
So you have to see that.
So Lordship will have it
And
after
then
a week.
only thing is that, say, supposing if at all it appears that you have not disposed of their objections,
Right.
then what would be the consequence of that in the proceedings?
As I understand, my limited understanding, it may be interfered only to that limited extent of those petitioners, not for the rest.
Can't it be done? Like, see, like if we quash, interfere with the proceeding, we will have the liberty to draw fresh proceeding.
Yes.
No, well, the
That
question
is
is
the
whether it can be
normal
quashed.
consequences.
I'll point out why. Because my learned senior friend, if I remember correctly, has pointed out on earlier occasions, but some of them already accepted the compensation.
Their name struck off with Lordship permission.
So
That was
that's
done
another
already.
issue. How do we set aside the entire thing?
No.
Some of them already accepted compensation from the same list of 89 people, which is
We
why I
will
was
place
saying
the decision.
it has to be limited only
We
to
will place
those
the
people
decision.
who are still aggrieved.
The matter has been made complicated now.
Yes. So it's not that easy to interfere with the entire thing.
Land acquisition cannot be proceeded for
Some
one
of them
person.
have acquiesced to
and
the whole
ignore
thing.
for
They've
2%.
accepted the compensation. So insofar as they are concerned, it's concluded.
Moreover, it will be affected in such way because there is a Pura Dalu route as a whole, and they are the only the 89 listeners there. Out of them, over 50 they have returned.
One second. Mr. Sangrejo,
Yes.
now those people, those who have withdrawn from here,
Yes.
now they were part of this writ petition.
Yes.
They
They
withdraw
wanted interference with the
acquisition process.
acquisition.
Yes.
Now, say supposing if we allow this writ petition, can we tell them to refund their money?
But they can different. But there are some Supreme Court judgments.
Will that just the judge can this court pass this order, and how far it will be binding on them?
My lord, since they are no longer a party, if my lord, what instant would be if he receive and still pursuing this matter here, lordship may take that.
See, they
Conclusion
originally they were a part of the
Yes, yes,
joint prayer meeting,
right,
isn't it?
right. And subsequently they
Now,
receive.
say supposing basically the locus standi or the relief claimed by petitioner is all were identical and
Yes,
similar at the institution of the writ petition.
yes, yes.
Now, some people they withdrew because they found that they are on the situated on the different, or rather they accepted the claim of compensation, isn't it? Now, the original plea which was there at the time when they filed writ petition, will it not that will bind them?
My lord,
Say supposing the others are remaining,
yes,
you are a part of that. The prayer which remains in this writ petition to be considered for other writ petitioners, you also, those who left out,
Yes.
were also a part of that.
yes, yes. That is
So
true.
will it not that they say supposing this, or any order passed by them will bind them also?
My lord, lordship is correct. They brought
It's not a
common
case that
issue.
They were not at all a party. They were party.
Yeah, they were a party. Therefore, commonly they brought the common issue in the middle of the proceeding. They left with the leave of the throne of God. And if lordship desire to pass some order that may have
Now,
adverse
say
impact on,
supposing, say supposing
need
if
to
we
be heard.
find
Yes.
that passing of any order in this court
Yes.
will have a bearing on them,
Exactly, my lord.
can we add them as a respondent now here in this case?
My lord, my lord,
No, the normal law is that a decree will not bind a person who is not a party.
party. Exactly, exactly,
So, going by that proposition of law, we cannot pass any order,
exactly, exactly.
okay, which will bind a person who is not a party to.
Right.
So, a circumstance may come, as has been pointed by Mr. Sen, that some have accepted these things.
My lord,
So, if at all any order, as per your prayer, is to be made for quashing the acquisition proceeding, that will have a bearing on them.
Exactly.
So, they will have to become a party.
No.
So, is it not that we say that you have to imprint them as respondent now?
my lord, in that event, my lord, will
Yes,
place a
Mr. Sen, what
decision.
happened?
In my understanding,
Land acquisition
till the
would be
stage
set
of the
aside.
award is merely an offer from the collector. So it does not have that precedent of these judicial decisions where it will have a binding effect on the rest. Those who want to accept it, they can accept and they can happily proceed. Those who want to question it, they can proceed by questioning the Section 19 notification, or they can proceed under Section 64, whatever the case may be. I don't think it would bind anybody. So I don't think there would be any necessity again to bring them back on record, to interfere.
So that means that means it coming to that, this thing acquisition will stand first only as against
Only
those
as
parties.
against those people who want to challenge it.
So then it means
Not-
if any fresh acquisition is to be Again, if government still
Lordship.
proceeds to acquire that land, they'll have to initiate another fresh acquisition.
Yes, that is the
No,
logical
the question then would be if
consequences.
Lordships find there is some procedural irregularity with the Section 19 notification and requires a hearing, it does not have to be set aside completely.
There
It
is
does
a
not have to
cases
be set
of
aside
lordship is
completely.
set aside.
That is what you see. You are
It is
defining.
a-
You see,
we'll place the decision.
Senior counsel says something else.
My lord.
So then I think
Section-
I would also want to be fair,
acquisition
you
can be
supply
set
me a
aside.
copy of
Plus,
those
see,
decisions.
things have become very complicated now.
Lordship.
Your Lordship, then another problem will come up out of this notification for acquisition. And when there is no stay, and subsequent works also has been proceeds on the basis of the notification. So if it is whole notification is quashed, then what should be the consequences?
There is what
They
we
have to face the
discussing.
consequences. The respondent, they trammel over the law, procedural law. They try to take over without adherence to rule of law. Consequences come, they have to face it. If lordship set aside, if lordship set aside,
No objection at all, and they have taken the conversation.
if lordship set aside the entire proceedings. Now the state may take an action. Either they want to proceed afresh, they can proceed afresh. That's what Supreme Court says. If they don't want, they can stop it. Their owner cannot force them. If the respondent release some amount to anyone, they have a right to recover it. We'll face the decision.
There's just another aspect. If your Lordships will have
Otherwise,
one
my
particular
lord,
order which was passed.
then land owners, there cannot be 10, 11, section 11 notifications. There cannot be then section 19 declaration. It's the same project, the same policy decision.
My Lord will just have one particular order. Order of this Honorable Court dated 7/8/2020.
Thing has become very, very complicated.
Lordship. Isn't the miscase? It's perhaps that order is in a
Yes,
miscase.
yes.
It would be in a miscase, I believe. It's miscase number 125 of 2020. They were pressing a stay.
No, here it is. In the main case, different is.
My Lord, so it would be in a miscase, my Lord. Miscase 125. They had filed a miscase along with the main writ petition, praying for stay of the entire land acquisition proceedings.
Yes.
In that, certain observations were made. Kindly have page 2 of that order.
Yes.
The last paragraph, beginning with having regard.
Yes.
So we had raised an objection saying this is a public, this entire project is in public interest and it would cause a lot of grievance to the people. Court has come to this conclusion. Having regard to the learned counsels on the interim matter and giving my thoughtful consideration to the prayer of the petitioners, it is noticed firstly that the widening project, by the own statement of the petitioners, has commenced since the year 2000, since the middle of 2019. The petitioners have come before this court only after the impugned declaration dated 8/6/2020 under section 19 was published, which by their estimation has excluded other sizable portions of their land. As per the declaration, hearing was already conducted as per section 15 of the Act, the report of which is annexed 22 of the writ petition. Looking into the facts and circumstances as they stand at this stage, the petitioners having approached this Honorable Court after a considerable period of time after commencement of the project, the question of any orders issuing to suspend the same does not arise and this prayer is rejected. However, as there is a significant removal of trees and also some demolition of structures from the project site, it is expected that the respondents of the agency engaged in the project maintain records as to the specific areas from where the number and size of trees have been felled and removed, and also keep records of the location of the pakka structures which have been demolished in the course of the widening of the highway, which will be subject to further orders to be passed by this court. They did not challenge any of this. So proceedings have gone on.
Any of this means what?
My Lord?
Any of this means?
The entire acquisition process at that stage, my lords, they had not been removed at it. They had not been displaced. But by virtue of this order, the displacement carried on. So they were not in possession of most of these areas. But they did not challenge any of these orders.
You want to say interim order will bind them?
To some extent, my lords, because the project has, I'm not sure what is the stage of the project,
See,
but
because taking into consideration the public interest involved in it,
my lord,
The court at that point of time
Lordship.
thought it not proper to interfere,
Lordship.
and
No,
it
I'm
has
saying
made a direction for keeping a proper account of a proper record of whatever
Lordship.
properties were situated on the land in question. Now that is what. Apart from that, what else?
No,
is
well,
it?
why they were content with this particular order. They did not challenge this. So these trees have already been felled. Now the question is, how do we ascertain all of this? This will have to be ascertained by the collector in the land acquisition proceedings.
So
So
you
I
want to
think
say-
the essence of the grievance today is that they should be paid for that 25 feet.
So you want to say the land acquisition proceeding has proceeded,
Yes, my lord. And they have
once
acquiesced to that.
Once it is proceeded by virtue of court's order,
Lordship.
you now cannot.
The question of interference
See, you
now
cannot
and
go
setting
back.
it aside, it's a very difficult procedure, my lord. And I think the essential grievance they have right now is only with regard to the exclusion of the 35 feet. That's all. Nothing
No,
more than that.
We cannot move back, isn't it?
Lordship,
We cannot move back.
Perhaps my
in
learned
this
senior
situation,
is-
the only relief available to them is to claim damages or the compensation,
Yes.
whatever. Nothing more than that.
which is why the others have happily accepted the compensation and moved on. Now, today, my learned senior is raising this objection of procedural non-compliance. But all this while they were relying on the division bench's decision, which relates to the 35 feet, the question of title. Even today, their grievance is only with the exclusion of the 35 feet.
That is exactly. If it is the issue was so simple, it was simple as like what has been contended, like the
Yes, my
non-compliance of section 15.
Then they would have argued on the very first
It
day.
would have been decided.
This matter could have been argued on the very first day. But they're attaching it with the matter before the division bench. So the dispute, the grievance as on today is only the exclusion of the 35 feet. That's all.
See, the interim order here also, you see from these things, it says the petitioners have come before this court only after impugned declaration
Yes.
dated 2020
Lordship.
under section 9.1. Under section 9 was published, by which their estimation has excluded other
Yes,
sizable portion of their land.
Yes.
As per the declaration, hearing were already conducted as per section 15 of the Act, the report of which is annexed to the rate petition. So it appears that there was no challenge or no plea at that time. That report under section 15 was passed without hearing.
My lord.
We have challenged that one.
No, they may
It
have
is-
taken a
it is-
plea,
it is-
but during the hearing, they were only insisting on the exclusion of the 35 feet. That was the main basis and the main foundation of their case. And I respectfully submit was that is still the foundation of their case today. Because they still want this court to await the determination of the division bench's order. And that only relates to the 35 feet. That's all. So let's assume for a moment that the collector now decides to pay them for the 35 feet. They will not insist on the non-compliance of section 15 or section 19. They'll be more than content as long as they have paid the compensation for the 35 feet.
What is your ultimate relief, Mr. Sangesh?
But my challenge is here, non-adherence of section 15. That is the sole ground. And with regard to 35 feet, that we challenge, we also challenge that one. Now, interim order was passed by this honorable court at that stage of time when we pray for staying of the impugnation notification. This honorable court held that no, you come after 2-3 months after declaration. So we will not suspend the operation of the impugnation notification for public interest. However, they have to maintain the records. That doesn't preclude, my lord.
So that means, meaning thereby, if this interim order remains, if it is not challenged, then your claim is only confined to the compensation, what the record would say.
No, precisely.
You'll be getting value for all those things. not
No,
yours.
my lord, my humble submission would be that interim order doesn't preclude this honorable court to examine the legality of the process, inquiry, the acquisition process.
You may be correct, but then the thing is that what relief then? You see, we cannot pass clashing order. There may not be a bar, as you say, correctly say, for the court to go into all those issues of non-compliance of section 15.
Exactly.
But then question would remain that the action which has followed that interim order,
Yes, my lord.
how do you undo all these things?
Lordship.
Can it be undone?
No, my lord, now they have done the acquisition in few kilometers. In our area, some of the requisition area, it is yet to touch also. Now,
Mr. Sanglisho,
No.
after this interim order, which was in operation for almost 4 years now, after this, if any interference is made at this stage with the acquisition proceeding, what would be the consequence to all those action which has been taken place in all those 4 years?
my lord, that will be set aside. My lord, if this honorable
What
court
is the
come to know,
consequence? See, it is not set aside in pen and paper. How that order will be executed?
no,
Now,
my
say,
lord,
supposing this thing, the road has been constructed,
Yes.
then what happens? That road will be broken. You will be getting back.
No. My lord, therefore, this Honorable Court consciously made it very clear that the respondent should maintain the records. Even if the entire acquisition is set
See,
aside.
maintenance of record and undoing a thing is different thing.
Records for the purpose of the felling of trees.
No, including the
Whatever
location,
loss they
including the
suffer,
land.
they should be compensated.
Including the land.
For that
Lordship, kindly
purpose.
see the order. Including the land. Records of the location of the Paka structures.
Yes, the
Not
Paka
for-
structures.
Not for trees and the.
Also, an location of Pakka structure
Included
has
the
been
land.
demolished in this course of versioning of. So it is only that part. And
Yes.
that means what? Now, if that record is maintained, which way it helps you? Just tell us.
My lord.
It helps you in making your claim for compensation. Nothing
Yes,
else.
Correct.
This if you have not challenged this interim order, then which way there will be scope of interference at this stage?
My lord, this interim order is a balance interim order. Taking into account both sides, the interests of both
That is why
sides.
this court is asking you,
Both
in
sides.
the event that you are successful in this writ petition, okay, and if the event, this land acquisition, in respect of these writ petitioners, are quashed, acquisition proceeding,
Yes.
then what happens to all the action which has been taken in pursuant to the passing of the interim order?
My lord, these actions are always subject to the outcome of the final decision of this Honorable Court. That is the law. That is the law. That is the law.
We understand.
But
We
incidental
understand,
action.
But then can
my
be
lord,
the tree which has been cut, can it be rebuilt?
no, it cannot be restored.
So you see, now then what happens? Then what happens? You have to be compensated. Now, if your compensation is to be given to you, that has to be given as per the terms of the thing,
Exactly.
acquisition,
Exactly.
or you have to file a case for damages. Then.
My lord. What
what
happened, Lordship? In view of the interim order, respondent proceeded to take action, felling down one tree. Now, later on, my lord passed an order set aside entire action. My lord, respondent cannot go scot-free. They have to pay the damages to the petitioner.
No, that we
They have
admitting.
done illegally.
At that
Ultimately, the
stage,
entire action, at the end of the final examination by this
if,
court.
if any road is constructed, then what will happen now? This road will be owned by you after acquisition? That is the question.
Now, therefore, they have to start afresh by affording opportunity to petitioners.
Mr. Sanghanesh, you think over and reply. You see, I do not know. Probably your reply is not very convincing.
Then we will satisfy.
See,
We'll satisfy.
this court is interested to know that the action which followed this interim order, what would be the consequence on those action if this writ petition stands allowed?
Yes.
Lordship.
You verify that part.
Yes,
Wakalatnama,
yes,
signing
that's
of
section 15 and
Wakalatnama,
also
what
that
is
issue.
whether signing of Wakalatnama by so many person fulfills the requirement of these things or not.
Not also maybe just for our clarification as well as the courts, we may be, the petitioners may provide the list of all the people who've already accepted compensation. That will help us to some extent.
That is the intermiss case.
Out of the 89 people,
Intermiss case.
how many
This
people
case
have
is
already
going fine.
received compensation and moved on? Who are not?
Then your record will say that.
Exactly.
No, correct. There was a lot of issue with this
Why
one.
don't you
If
call
Lordships
for
will
a
recall,
record
I can do that as well.
from your collector, and then your office can compare it here.
Lordships.
Okay. We'll just simply adjourn in Mr. Shan without
Lordship.
saying anything on this. This matter, just see, try to come to a thing, you see, like which we can solve the thing. You see, perhaps whatever you raise from your side, many things at this stage seems to be acceptable. But then if we accept all those contention, then it will be difficult for the court to come to a conclusion.
Lordship.
Now, which way we can come to conclusion and correct a legal conclusion, that is what matters.
I think what we are left with now, as far as the state is concerned, leaving aside the 35 feet, we are willing to pay whatever compensation is required. In case they're not happy with the quantum of the compensation, they can prefer necessary reference proceedings. But what they are still going to agitate is that 35 feet which is being excluded. That is the main issue.
No, but then if you see the arguments which
Yes, that is on the question of non-compliance of section 15. But also I think they would be happy.
if parties want that there has to be some finding by this court, then we have to decide this.
Lordship.
That is the
And
rule
it
of
may
the
have
issue.
if we decide on this, then we may not go to that issue of 35.
Lordship.
So that is what we do not know. Say like, see, it depends upon the parties which way they argue the matter, and what relief they really actually this. And then if they are interested in getting this acquisition matter set aside, if they do not have any interest to compensation, they may not take the order.
Lordship. And Lordship, can you have it after 2 weeks? We'll take instructions from because it's coming from Garo Hills.
You made this matter very complicated. This will be. We just say on the request. Just say Mr. S. and Learned GA. Place for grant of some time for further preparation in the matter. Mr. Senior Counsel applying for the petitioner has no objection. Red alert list after 2 weeks. See, Mr. Sangleshu, just see what kind of things, because it seems that the passing of this interim order, especially continuation of that,
I'll say
has
this.
created it has the effect of creation of some complication in the matter. Even if repetition is allowed, which way those actions which have been taken in pursuance of this interim order can be undone, or if at all you want that some compensation to be paid to you, then that means like this cannot be done here. You have to file a separate case for
Separate
damages.
suit then in that case. That's a relevant observation, my lord. If the
Different
trees are
issue,
felled
madam.
and Pakka structures have been removed.
No,
We will
that is
satisfy.
assume it is filed. This is 4 years.
Yes.
Only it is to be assessed. So that assessment will be done by the official authority.
Yes. Lord.
Collector.
Okay.
Is the duty of the
Now,
collector.
only thing is that then in such a case we cannot order, except for ordering, if at all they're successful, ordering interference with the acquisition proceeding, we cannot give any further relief.
My lord.
No, do not know why there is cases. Now you want this to be
No, Lordship can keep it for the records. Oblige, my lord.
it is interesting.
Deeply obliged.
Item number 2.
It's too heavy.
Oblige.
Item number 3.
May I please, Your Lordship? We took steps for respondent number 4, Lordship. We took steps. for
Loud.
May I please, Your Lordship? We took steps for respondent number 4, Lordship. We need to. Yes, Lordship.
4/6. What date is today? Today is
28.
28. You have taken steps on 4th. And Where is the address of this thing? Respondent number 4? Which place?
William Nagar, Lordship.
Does it take so much of time within the state?
Next state, Lordship.
Will you verify the status by yourself
Yes, Lordship.
and file an affidavit to that effect?
Yes, Lordship.
Yes. From the office note dated 27/6/2024, comma, it appears that the acknowledgement of service of notice upon the respondent number 4 has not yet been received. Stop. The learned counsel for the petitioner prays for grant of some time to verify the status of service of notice upon the respondent number 4 and filing an affidavit to that effect. There are alert list after 2 weeks.
Highly obliged.
Item number 4.
Yes.
May it please your lordship. My lord, the petitioner in this petition has challenged the order dated 18/07/2023 passed by the learned trial court, by which my application for default bail was rejected by the learned trial court. May I take your lordships to annexure E, my lord. Page 19.
Yes. 19. Yes.
Uh,
There is no page 19.
Annexure E, my lord. Annexure E, sorry. The last page, my lord, of the petition.
Is it page 18?
Page 19.
There is no
Order
page.
order dated 18/07/2000.
No, but there is page 18 here, no 19.
My lord.
The back side. That is page 18. Marked as page 18. Previous page is page 17. Annexure C starts at page 17.
It's page 18, my lord.
My copy is marked 18. There is a difference. How can there be difference?
Okay, my lord, I may be allowed to be corrected.
Yes. Let her correct the page numbers. There appears to be a mistake in the pagination of the writ petition. Learned counsel for the petitioner seeks for grant of some time to verify. What you said, there appears to be started with? Okay. Learned request for some time to correct the side mistake. They allowed list when?
My lord, maybe tomorrow.
List after that. One Saturday.
Monday, my lord.
After.
Highly obliged, my lord.
Supplementary consists hearing item number 1.
Yes.
May it please your lordship. Lordship, this is a matter relating to the notices that were challenged, declaring us as willful defaulter. Lordship, on the last occasion, the bank had stated that they do not have an objection, but they'd like for us to file a representation to them so that they can remove us from the blacklist.
Are you willing to do that?
No, Lordship.
What?
As instructed, Lordship, we are unwilling to reach out to the bank in any form or manner, Lordship, because the dues have been cleared from our end, Lordship. So I'm praying if this matter may be listed next week to be heard on merits.
There is already, we have not recorded anything
Lordship.
with regard to or by directing you to approach the bank. There is no such order. So it is always open for hearing on merit.
Lordship.
Okay, on the prayer of the. Who is appearing for the bank?
And for the respondent, Your Lordship.
So you still have that same submission. What is the problem? If we set aside that thing here, why do you want them to come and file an application to you?
I have no idea, Your Lordship, because I'm appearing on behalf of the.
Okay, so you are not appearing on behalf of the bank. You are appearing under instruction of some lawyer.
Yes, Your Lordship.
On the request of the petition, I'll list after.
Highly obliged, Lordship.
Mainness item number 5.
Lordship, we had filed an application for recalling of the order dated 16/7/2018.
Yes.
Now I filed my application on 4th April 2024.
Yes.
Now the opposite party has not filed any show cause even till date.
Your Lordship, on the last occasion, we had prayed for a 1 week time because we are waiting for the petitioner. Today he is arriving, so contingent to the petitioner arriving within the filing hours, we'll be filing it in due course of the day. But if he does not arrive here, I just pray that Your Lordship may allow us to file it on Monday, positively on Monday. He's arriving today.
And the request made by the. Are we passing any order, separate order in this case?
Yes,
There is.
yes. Because I'm the opposite party number 1 in the miss case.
Yes, in the miss case. There is in miss case number 51, isn't it?
Yes, 51 of 2024.
Well, just say. And the request made on behalf of the opposite party number 1. Another 1 next time is granted.
It will be a last opportunity, Lordship.
Okay. 1 next time is granted as last opportunity for filing an objection in the matter. List accordingly.
Lordship, I only pray that in the event if the affidavit is filed by them, I'll be granted liberty to file rejoinder. In the event if they file.
Fix it for hearing.
We'll see if
We
rejoinder
will
is
not
here.
Round stick.
See, we cannot. This way, we just nothing. We increase the volume of the thing. In the writ petition, you do not have unlimited right of like exchanges, trading.
Lordship, we'll see. We'll see
Some
the
stage. You see, even filing the right of filing rejoinder in writ petition, that comes only after court permits.
Lordship,
But
we'll
then
see.
here it goes like anything, every way. See, in the main case, after running this thing, and in the main case, in the main writ petition, 412, we just say list after which. List after.
Obliged, Lordship. Much obliged, Your Lordship.
Item number 6.
Yes.
My apology, my lord. In the morning session, my lord, I had made a submission to bring on record, but as per my latest, my lord, understanding, my lord, the report has not reached, my lord. So I'm praying for a week time of.
Well, Mr. Arguing Learned GA pen for the state is granted. After 1 week. 1 week or 2 weeks?
2 weeks will be, my lord.
You see, we walk here. See, it is useless taking time 1 week, 1 week every time. You just take a longer time, a longer period, and make sure that your officer concerned passes.
2 weeks.
This you can do once you pursue them. That
My
if you remain silent, that will never.
My lord.
Further 2 weeks time is granted.
Deeply obliged.
To oblige. Is granted to obtain instruction.
Deeply obliged.
Item number 10.
Obtain necessary instruction.